Morning, everybody. How was last night? Fun? Anybody make any money? So I want to thank you all, first of all, for bringing winter here right when I landed. I appreciate that. It's really amazing. I came from Miami, so I'm struggling a bit with the weather. So I'm very excited to be here, and a bit of reminiscing, if you could bear with me. I remember when the South Dakota Trust Association started. I remember when Jessica Beavers, who's sitting somewhere in the back there, came up with the idea, I believe. Her and Anthony Jaffe and I think Matt Tobin were the original founders. And I remember talking about the vision of what became now the South Dakota Trust Association. And now look what has happened over the last couple of years or multiple years, and look at this event. The group, the association, needs a huge round of applause. Congratulations. It's an amazing organization, and it's recognized all over the country, and this is exactly what we need to support Bridgeford, or to support Bridgeford, of course, South Dakota. As many of you know, we're very passionate at Bridgeford about modern trust law. In 2011, we came here from the Northeast, much like Anthony Jaffe did from the Northeast, because we fell in love with modern trust law, and in particular, we fell in love with South Dakota. We're humbled at Bridgeford to have been able to grow a story, to promote Bridgeford across the country, to promote South Dakota and what we're doing across the country. We're doing great work. Our growth has been great. We have 8 or 9 trust officers, rep offices in California and Miami, and we're singing the song of the power of modern trust law in South Dakota, and we couldn't be more proud of it. Particularly now, because the industry a bit has kind of been under fire, which is going to lead to our discussion as to the genesis of why we even have to deal with the CTA. You know, the Pandora Papers, different data leak. Pandora Papers in particular fingered South Dakota. And Terry Prendergast and others took a leadership position and this organization to defend our industry. And isn't it amazing that we were put in a position to defend ourselves? It's incredible to me that we had to defend ourselves. I could tell you we do a lot of speaking and writing, and I found people were saying things to me like, well, Bridgeford in South Dakota helps rich people, hide taxes. We help bad actors. We do bad things. And that's not what we do. What we do is protect the integrity of the trust industry. I think it's exactly the opposite of what we were accused of doing. So I believe as we begin the discussion, which I think is a little bit of an attack on privacy, which we'll get to, is we should not be ashamed of what we do. You know, it's like a chess game. Life is like a chess game. Estate planning, wealth planning, it's a chess game. Those who know the rules of the game typically win. We know the rules of the game. So we're bringing asset protection, privacy, which is, again, I think is a little bit under attack, and tax planning, not tax evasion. So again, I think we should be proud, and maybe that's another round of applause. We should be proud of our industry. We should be proud of our regulators. We have a very, very powerful story to tell in South Dakota. I think we should be really proud of that. So just a quick hello to our Bridgeford people. We have Vicki Lickness here from our peer office. We have Doug Mickenden also from our peer office. Looking for Jamie Frisk. Where's Jamie? Over there? Okay, hiding in the corner. We have an intern with us who's been doing a great job, Gannon. And we also have Chris Halverson with us from Bridgeford. So again, thank you all for being here. So as I said, the Pandora Papers, CRS, all this conversation about perfect privacy became an issue for us to have to wrestle with. So whether we liked it or not, in all due respect to our regulators in the room, the United States became what? Became a tax and a privacy haven. Why? It's no secret. CRS happened, and South Dakota in particular became what? Called Little Switzerland. We didn't like that name, but the reality is we still have the most powerful privacy laws in the country, even in the face of the CTA, which we'll talk about in a second. But we didn't like this in particular, right? I mean, people were concerned about this. The world was concerned about this, right? Because the United States refused to sign off on CRS. So then all of a sudden, the Bahamas and Cayman Islands and all these offshore jurisdictions, they lost business. And I'll tell you a funny story. Well, right after CRS was passed, Bridgeford does a lot in the international space. That's a big area for us. And I was in Cayman Islands, and I'm not exaggerating. It was a STEP event. I had a group of people, trust companies, really yell at me, saying somehow I was responsible for us not signing off on CRS. They were so upset that we were taking so much business. So the reality is it created a problem, though, at least in the eyes of some folks, because the U.S. wouldn't sign off on CRS. We had FATCA, that was the argument, right? But there was a need for further transparency. There was a need for the United States to, I think, nod to the world community and say, look, we get it. We get it. Maybe there's more transparency. Maybe we need to do a little bit better. Here's a quote, though, that's going to guide, in my opinion, the conversation today, and I think should guide the way we approach the CTA as we go forward. We're not talking about secrecy anymore. We're talking about privacy. We're not talking about hiding information from our government. We're talking about keeping our information private from one another. I believe we have a right to privacy. I'm proud of South Dakota's privacy provisions. I don't love the CTA. I think it's a little too invasive, and I think it's a little too convoluted, and I really want to solicit input and comments as we go through this, because this has been talked about for so long, maybe too much. I mean, I'm kind of tired of hearing about it. I'm kind of tired of talking about it, especially since I really don't understand it. I'm kidding, and then a little bit, understand a little bit. That was a joke. Come on, I did. But before we get to a more little memory lane thing, right when the CTA became an issue, I was in Miami, and somehow or another I was asked to be on a panel to talk about the CTA. And this is back when all the comments were flowing around and everybody was panicking, and we thought, oh man, the United States is going to create its own version of CRS. It's going to start to share personal and private information to people all over the world. Oh, the world's coming to an end. No, privacy's dead. And so I get tapped to go on this panel. I understood a little bit what the CTA was, but at that point, nobody really understood it because everybody was fighting about it, right? So of course, what I do every single time I don't understand something, I call Terry Prendergast. I said, Terry, what the hell is this? And what am I supposed to say on this panel? And guess what? He knew the answer. Does that surprise anybody in this room who's worked with Terry? And so that's when I really started to take a closer look at the CTA, not just the mechanics. The mechanics aren't that complicated. The rules aren't that complicated. The questions really are, what are the implications for our clients? What are the implications for our, for not only clients, but the different institutions that we work with? And the question becomes, again, is privacy dead? Absolutely not. Not in South Dakota, for sure. So let's have some fun going through in meticulous detail, line by line, the legislation. Is that okay? But you guys are still waking up. If you want me to, we can. I'm just kidding. I want to quickly kind of dance through the requirements. You've all been pummeled by the CTA. Everybody's doing a webinar about it. Everybody's talking about it. It's not that, in my opinion, the rules themselves aren't that complicated. It's more the exceptions and the gray areas that I think is tripping us up, which is what we're going to focus on towards the end. We all know it became effective January 1. We understand its purpose. Essentially, it was to prevent money laundering, tax evasion. We all know what it's for. Increase transparency, target bad people. I think when we come to the end of the talk in 5 or 6 hours, when I'm done, I want us to really ask ourselves that question. Is this really going to hit the objectives? Is this really going to weed out bad actors? Do bad actors really care about filing with the CTA? Probably not, but the good people in the room and the good people in the world and people who are trying to do the right thing, guess what this is? Excuse me for saying this in South Dakota, this is a pain in the ass for the good people trying to do the right thing. All of us in this room. Can we agree with that? And so the question then becomes, are we really going to accomplish this objective? We'll see. I don't believe we will. So the definitions are pretty clear. I'm sure you've all gone through the details. Reporting company, how is that defined? I'm not going to read that to you. It's pretty clear what a reporting company is. But the devil, of course, is what? In the details? In the exceptions, right? So when I was in law school, it's like, here's the rule, but then there's 50 different exceptions, which means, what's the rule mean, right? Here's the exception, probably, that's most important to us in this room as the Trust Association members. Who's accepted? Why do we care? Trust companies, right? We all agree? But does that end our responsibility as a trust industry? Do we just say at Bridgeford to the thousands and thousands of clients of ours who have LLCs that we hold in trust, that tangentially we're responsible for, even in a directed trust scenario, do we just say, figure it out, sign this waiver, not our problem? Even though Bridgeford or all the other trust companies aren't required to file this. Well, of course the answer is no, right? So that's what I'm saying. How this works is important. How we handle it is more important, because you got a whole bunch of clients all over the country worried about how to do this, when to do it. Some are waiting. Some believe it's going to be ultimately deemed unconstitutional. I don't know. I don't think it's going to happen before all the deadlines come. But the reality is, how do we deal with it? Not so much how does it work. Beneficial owner, it's an easy definition that's very consistent with other definitions of beneficial owners that we're all dealing with in various aspects of our practice. You know, I like the quote at the end there. You know, this is designed to close loopholes that allow corporate structuring that obscures owners or decision makers. Really? You think that's really going to be the solution? Is that what we're going to see, or are we just dealing with a bureaucratic bunch of red tape? And it's confusing to me to see the analytical, the law, and then the practical implication for everybody in this room. Very confusing to me. So we know what is reported: full legal name, date of birth. Again, not complicated. The form itself is not complicated. The filing itself is not complicated. What's complicated? Figuring out sometimes who has to report, right? That becomes the legal question. That's why Bridgeford, and I hope none of our other trust companies in South Dakota are actually doing the legal work, right? We don't want to be giving legal advice unless you're an attorney that has malpractice, which I don't have anymore. So anybody who has a complicated question, I'm going to defer to Terry and other licensed attorneys so I can't get sued, okay? I got to get you guys up, and I mean, were you up late last night gambling and drinking? What's going on? Is the snow upsetting you? Come on, guys. Penalties are real. We know the penalties are real. Again, I'm not going to read them to you. I'm sure you've heard this a million times, but this is no joke, right? So we can't ignore it. It can become expensive. It can become a huge problem, especially for trust companies whose clients suddenly come out of the woodwork and say, I didn't know I needed to do this. Well, it's not our responsibility to do it. Why? Because we're exempt, but we still have clients to serve, right? Law firms still have clients to serve, not their problem to necessarily file it. So there's a lot of people, surprisingly still, after all the chatter and all the conversations and all the webinars and everything, that still have really no idea what their reporting requirements are or how to do it, which is interesting because it really isn't that complicated, right? And so I guess that's why we have to continue to have these conversations. But it's our responsibility as an industry to handle this and address this in a way that makes sense. And so that's really what I'm trying to focus on. You know, the storage of information, there's all kinds of promises that this information is going to be safe and protected, right? Well, we thought that was the case before the Pandora Papers happened, with all that data and information that we all thought was safe. So that's the question I get from people all over the country and all over the world. Is this data really going to be safe from a security breach, from a cybersecurity breach? We sure hope so, right? We sure hope so. If not, it's a calamity, and we just hope that that doesn't happen. These phases, I just wanted to just linger on this a bit, just because they've changed. You know, I think the most important point, and then we're going to drill down on it a little bit, is when FinCEN starts to share this information. Because if you remember, because I remember very clearly, because I got this question probably 100 times when this first came out. Well, what's FinCEN going to do with the information? And initially, the answer was nothing. And then all of a sudden, it became something. And then all of a sudden, it became clear, oh yeah, this information will be shared with outside countries, as long as they have to have a reason, and we can get into that in a minute. But the point is, the ball kind of shifted, or the ball was kind of moved around a little bit. I don't know if you remember that change. I remember it because the first time I did a presentation that Terry helped me prepare for in Miami, the answer at that point was, they're not doing anything with it. They're just collecting data. Kind of a change, right? Kind of an unhappy change, in my opinion, because now some people are very, very concerned about where this information is going to go. And I think it's well-founded. I do think it's well-founded. Ongoing debate. From the very beginning, from the first time I heard of CTA, people fought about this. People are saying it's too invasive. Enforcement is viewed as impossible. I mean, I heard a statistic from Terry. So, okay, there's 35 million filings, 328 employees. I mean, how is this really, I mean, honestly, we're being honest with you, is that enough people power to chase this down, to make sure this thing works, to protect the world from nefarious individuals? Absolutely not. And so I've said that from the beginning. Look, if you're going to put something in place, I get it. We all want to be compliant. I don't want to work with a bad actor. None of us want to put South Dakota on the front page of the New York Times. And the regulators do a great job making sure we do not do that. So I am a believer in disclosure to a point. But give us a system that's workable. And that's my concern. I don't think it's workable at all, in addition to the constitutional challenges that we're dealing with. And so it's really, and I'll say this too, and it's a little controversial. It's actually kind of embarrassing, if I could say this. I mean, I love America and I love South Dakota and I have all things positive, but in the eyes of the world, we look a little foolish. I mean, CRS was debated, but it was executed. It doesn't execute perfectly, but that seems to have been a lot easier implemented than this is. And we're the United States of America, with some of the smartest people on the planet. We can't come up with a disclosure program that doesn't, it isn't overburdened or too burdensome or otherwise even unmanageable. I mean, I think that's what we have, and I can tell you in Switzerland, and where's John Ryan? I saw John Ryan around here somewhere. There's John. I mean, please chime in. I mean, I would imagine people in Switzerland think we're a little bit of a joke at this point with the CTA thing because it's so convoluted, and all just the comments alone, we couldn't even agree on the definitions of some of this stuff, right, John? I mean, feel free to comment. Did you get any feedback in Switzerland on this?
Well, I think in large part, CTA was born out of pressure for international law.
Absolutely.
Information on beneficial owners.
Right. John just said, and I completely agree, CTA grew out of pressure from the international world to just figure out a way to disclose beneficial owners, in part.
Also, FinCEN has been used as a tool for domestic tax evasion.
Say it again one more time.
To counter domestic tax evasion.
Yes. John also said FinCEN has been used historically to counter U.S. tax evasion, that sort of thing.
You used to be able to create an LLC without giving any information.
Right. No, I agree. And I agree with you, and I think that what John said. John, I'm sorry, keep going. I just want to make sure everybody knows what you're saying. Say it one more time.
No, I'm saying there's a balance to be struck.
Absolutely. So John says there's a balance to be struck, which is exactly what I'm trying to say. Clearly, there's a need for the disclosure of beneficial owners. I'm not arguing against that. I'm arguing and I'm concerned about the mechanism that's put in place. That's what I'm saying. I don't think it's workable. And so we know about the Supreme Court case, very interesting. I was pretty struck by that. I know there's other cases pending, some legislation, and it goes to my point. I'm amazed at how many people and how many clients and how many folks are like, I'm just gonna wait to the end of the year, let's see how this thing plays out. Well, it's almost November, right? I mean, and what about all the folks who don't have a sense of really how it works? If FinCEN can figure out how to police these people and find them, they will find them. And they will arguably, allegedly, put them in jail because they didn't fill out a piece of paper. I mean, it almost becomes sublime after, if you think about it too much. And I try not to think about it too much because I think it's unfortunate the way it's coming out. So there's a lot of discussion about, as I've said before, about the concern of where's this information going to go, how is the information protected, and there's a lot written on this, and there's a lot written on who can access it, and that is, again, in my opinion, that was a little bit of a changing of or moving the ball around. So when somebody wants this information, and I was talking about this with Terry, when I say somebody, I mean institutions, other banking institutions can share it, that's fine. But what about Mexico? Comes to FinCEN and says, look, we want the information of beneficial owners. Well, we know that privacy in Latin America sometimes is an issue of life and death for these large families, right? So we could all presume that because somebody's in Mexico, they're a bad actor and selling cocaine, but actually that's not been my experience. We work with Mexican families and the ones we work with are pretty amazing and deserve privacy. So their concern is, where's this information gonna go? Is it going to go back to the very people the whole reason why they came here is because they didn't want their government or other people to know that they're rich because they don't want their kids to be killed. That happens. It doesn't happen in the United States. So the question is, when Mexico comes calling the FinCEN, what's the standard? What's the question? How do they get it? How do we decide? How does FinCEN decide? I don't think that's clear. If somebody has a thought on that, please jump in. I don't think that's clear at all. Raises a red flag for me. Not for us. In the U.S., look, we're lucky, right? We're lucky our kids aren't stolen. because we're wealthy. Well, I'm not wealthy. Some of you maybe. I'm not. But I mean, that doesn't happen here. We live in a world here, we don't have those kinds of pressures. So I mean, I ask again the question, is anybody in this room clear on what factors are going to be considered by FinCEN to release information to the government of Mexico or Guatemala or anywhere? No. Should we be concerned as a trust industry? Absolutely. Especially in South Dakota, where we're so independent and believe in privacy so vehemently that we should really be on the front pages, so to speak, of saying, hey, we need to ask some questions here. We have to figure out a way to make sure we're maintaining some modicum of privacy for our families, because that's why they're here. They're afraid to have their information in the public. So there's penalty for misuse. There's all kinds of ways to, I guess, safeguards to protect the information. And then what happens if it's used inappropriately? That's fine. It's all fine. It's in place. But it still doesn't stop information going into the wrong hands, and it doesn't protect our folks. So the real question now that I kind of want to get some feedback on from you all as well. Said before, privacy is not dead, right? We've written a lot, talked a lot about how do you find privacy, asset protection, effective tax planning in a increasingly transparent world. Well, we can. Where can we do that? In South Dakota, for sure. And that's why we're so excited about modern trust law. That's why I think the CTA, while somewhat worrisome, again, hasn't killed privacy. And we all know that there's a couple different ways, and I'm not suggesting we actively try to get around it by using different structures, but that is an option. That is an option, although probably increasingly closed as a loophole, because FinCEN will probably, it's expanding this requirement. But we remember South Dakota. We have the strongest, I've said it before, and I love it. We have the strongest privacy provisions in the country. It's driving families all over the world into the United States. That's why people like John Ryan and others from around the world have put their trust charter in South Dakota. It's a big reason. It's why we did. Because, I said earlier, I believe we have a fundamental right to privacy, and we have a fundamental right to asset protection. They're not bad words, and we're not dealing with nefarious people, and what we're doing, again, is, to me, virtuous. So let's remind ourselves of South Dakota's amazing privacy laws. We know we have quiet trust. They're codified, unlike other jurisdictions. We all know the rule. So CTA comes and says we have to, give up the name of beneficial owner to some nebulous database somewhere that we hope isn't pierced, and then they reserve the right to share it with whomever they feel like it if they meet some nebulous standard that we don't know. Okay, fair enough. So, but at the trust level, we still can maintain some level of privacy. So that's the balance, right? All is not lost. I tell our, especially our international families, you're still okay, by and large, and you still have privacy. And you still haven't turned over all your information into the public realm, which is not what we would ever support in South Dakota, right? And that's what we stand for in South Dakota. I mean, 1983, right, when South Dakota became the first state in the nation to abolish the rule against perpetuities, South Dakota put its flag in the ground and said, we are going to be a leader in all things trust related. You can thank people like your task force and groups like this and Brett Aftal, who runs a great regulatory agency that keeps us all out of trouble, and the governors who have supported this. We should be proud of this and keep that top of mind, for sure. I want to make this distinction, and I think it might be an obvious distinction to all of you, but I think sometimes we're missing it. Sometimes I'm accused, and I'm a little outspoken about this, or saying, well, hey, look, Bridgeford's selling secrecy. David Warren's running around selling secrecy, and that is not what I'm saying. I made that distinction very early on, because secrecy is trying to hide from your government, and that's not what we're suggesting we do here. But this is where practicality comes back to life. When we're talking about theoretics and what does the CTA mean, and oh my God, how does it really work? Well, here's our answer in South Dakota. If the goal is to avoid money laundering, bad actors, bad money, right? Keeping Bridgeford and South Dakota off the front page of the New York Times, well, how do we do that? Well, our regulators have helped us do that. We have a tremendous KYC process that is streamlined, not only streamlined, uniform. And I remember when it became uniform, because we were one of the earlier trust companies to be in the international space. And every trust company kind of had their own little thing, right? So if John Ryan required one thing and I didn't at Bridgeford, that became a competitive problem in the landscape, because a family is going to go to the trust company that has the less requirement, and all of a sudden that trust company ends up on the front page of the New York Times. So Brett Aftal and the regulators did an amazing job unifying how we go about KYC, what we need to do for BSA, what we need to do for OFAC, what we need to do to protect our industry. So what I'm saying is CTA, fine, great, it's supposed to ferret out bad people. We already are doing that. We've been doing it effectively for many, many years in South Dakota, and I think it's a testament to our regulators. You know, I mean, I love our regulators. I mean, they help us to make us better. I don't always love the exam process, but what I'm saying is they have been a leader to protect our industry. So if we're worried about bad actors, do KYC properly. That's the answer, isn't it? Isn't that really the answer to protect the integrity of our industry? So I mentioned South Dakota Division of Banking. They've been amazing in terms of how they really on us on it, you know. And look, we're heavily monitored, heavily regulated. I welcome it. I welcome it. It makes Bridgeford better, stronger, and it protects our clients. And I think the division has done an amazing job. So as I wrap up, I do want to get back into some discussion of CTA. There's some recently promulgated, recently asked questions, or frequently asked questions that I thought we should get into, because it hit on some points that I have been thinking about. So here's the first one. Who can access ownership? We were just talking about that, the ownership information, right? So look at all these people and organizations that can access the information. It's a lot, right? Does that surprise you? Anybody, are you surprised? I was surprised that this many different people and organizations can pull this information when they want it. Transparency, privacy in a transparent world, I don't know. It's a lot of people that can pull this information without anybody even knowing about it. Comments. Does that, I mean, you don't have to agree with me, you know, because I mean, I know the goal is to make us strong. Yes, please, yeah, thank you.
Thank you for your summary. Thank you for your time. I do take some issues with your comments.
Okay.
One of the things that you are missing in all of this is, I'm a compliance officer.
Mm-hmm.
I transitioned from officer, I'm offshore. So I'm trying to see both worlds.
Mm-hmm.
And, you know, you see, sorry. The Corporate Transparency, the CTA Act is the true source, the true purpose is anti-money laundering.
Mm-hmm.
And I appreciate all your comments about privacy, protecting our clients and all that good stuff. We do all of that. But when we think about stakeholders in the industry, I know our regulator is here today, he's listening, and everyone else in this room is listening. And I do take issues with some of your comments. It's conflicting. It is disheartening at times. And I hope that people listening to this does not go away and get more confused and more disheartened by this legislation. So, you know, I agree with a lot of the things that you have said. It's a lot for us to do. It is a costly process when we think about FATCA. But it's something we must do. And if our clients are not doing something funny, they are not doing something illegal, then we really shouldn't have anything to worry about. Then you raise the issue about who have access to this information. One of the things you did not say is, I truly believe the US government would not just be handing out information like candies and have a portal where everybody can just log in and find out who owns what. I believe it will be a controlled situation. So I would say to you and the industry, let us give the government, FinCEN, some time to I would say, you know, to think about it some more. It was a rush situation, like John said, international pressures. The US have never had to play ball, and all of a sudden, because of those pressures, they have had to now agree to pass this legislation. So it is still a work in progress, and I hope that in the end, we know there's talk in Congress, bills being proposed to stop, to delay, to maybe change what it would look like. But for now, I think we have to behave as though this is happening and we must comply or make an effort to comply. And this is where I truly believe trust companies must invest in their compliance operations, employ qualified people so that they don't fall into hot waters. Mm-hmm. Thank you.
No, I love your comments. I love your optimism too. I love your optimism, and I agree. We need to give them some time to work it out better. And I also agree with you. Of course, it's here. I'm not at all suggesting we don't file. But I also think we need to keep our critical thinking caps on too. I mean, if what you say comes true and this is figured out and we do have some clear guidance, great. I'm a little less optimistic about it so far. But I'm not suggesting we don't comply for sure. But thank you, great comments. Everybody can see the question, is it accessible under the Freedom of Information Act? That question's come up a lot, and the answer is no. So that is a safeguard there in terms of who can discover the information. Another question that I thought was really interesting, because we've thought a lot about this at Bridgeford, is, is this the practice of law, filing these reports? Who should be giving the advice? Who should be determining who's a beneficial owner? Often people who own LLCs, they don't know the answer themselves, so they're concerned about that. And they asked Bridgeford, and we said, we don't practice law. Call Stefan, call Terry, that's a legal opinion. And so if it's wrong and somebody gets wrong information, clearly they're subjected to terrible penalties and all the things that we've already talked about. So I think it's really, really important to remember that while there's third parties doing this, and they're allowed to do it, and there are organizations that are popping up to it, when Bridgeford came up with our program to make sure our families were compliant and our trusts and everything were compliant, we were very careful of distinguishing, well, what is legal and what is an administrative filing. And I would encourage you all to be very careful. I mean, of course, we want to help our clients with this, but we also don't want to be giving legal advice if we're not lawyers. And there's a real fine line here, and especially since it's evolving, it's a very fine line. So please, I think that's one of my biggest messages is be very, very careful how you do this, how you execute this, because there's still a lot of uncertainty about some of the definitions. And this one I really was interested in, I hadn't thought about it. If a spouse has an ownership in a reporting company, community property state, does that spouse also have to be reported? Unclear. They say possibly. I would say in the interest of maybe a bit overkill, I would do that. I would absolutely file for the spouse as well. Even though they say it's unclear, I don't want to take the chance and have my spouse end up getting hit with a $10,000 fine and whatever because we just didn't do it right. So that's a really interesting question because most of our clients are married. Most of our clients have community property. South Dakota has a community property trust statute, right? So I mean, this is germane to that. And again, I'm not giving legal advice at all by saying just be safe and why not just file on the spouse as well and just avoid some of the problems. So I know I've said a lot and went through a lot of information on purpose. I'm purposely trying to spark debate. So again, I love your comments and appreciate it. But anybody, John, please, yeah. We have a microphone for John, yeah.
For a bit of context, I think the CTA is long overdue. Because if you look at the disclosure regimes in every legitimate international financial center, that when you create a company, you have to give the beneficial owner to the resident agent or to a regulatory body in that jurisdiction, like the BVI. So in that sense, the U.S. has been lagging behind significantly. Mm-hmm. And I think that in the law, FinCEN has articulated a legitimate domestic interest in this, quite apart from international pressure from the OECD and so on, mm-hmm. in combating money laundering and tax evasion. And when you look at what you have to give, it's really not that much. Mm-hmm. There's no financial information that is attached to the report.
Right.
And the beneficial owner, of course, in the case of a trust, is reported. The trustee is, the settler is reported when the trust is revocable. The beneficiaries are not reportable if it's a discretionary trust. So it's actually written in a very flexible manner, rather confusing, but in my view, it's long overdue.
Thanks, John. Excellent.
And one further point on the information share, there's a separate body of regulations that cover this. And information can be shared with foreign governments, very broadly speaking, if it's on request. And as you know, it's a non-public database. So the request from a foreign authority has to be made on request, and the U.S. will look at criteria. And they certainly will not share this with unfriendly governments. I think that's pretty clear.
Mm-hmm.
So,
we hope.
And I think that database will be secure.
Hope so too.
And if FinCEN can't run a secure database, I think we're all in a lot of trouble.
We'll
But
see.
I have faith in FinCEN, personally.
Good. Thanks, John. Over in the corner.
So I have no problem with the principle behind, this. I think we all agree this is kind of long overdue, but the two things that I find scariest about it are the vagueness of some of the rules. I mean, what is substantial influence? I know there's that substantial control, but buried in the subtext of those is this thing called substantial influence. Does a director have substantial influence? It's not clear. They say not necessarily. We're supposed to make subjective decisions about these sorts of things. I like the bright line rules about trusts. I think they're great and helpful. Although I know Step Miami did a presentation and they said, we think we should report all the beneficiaries. And that just boggled my mind. And I challenged them on that and they really couldn't give me a good reason, except I think they wanted to be ultra conservative. So I'm writing an article right now called Through a Glass Darkly, as you guys say, the CTA and trusts, and I hope to have it published before the end of the year so that, come the deadline, to explore all of these ambiguities. So I think that's the number one scariest part, is the ambiguities in there and the judgment calls that you have to make. But the other scary part, I think, is the sharing with foreign governments and how that's going to work in practice. Because if a foreign government can come and say, we're investigating this person, and they can go to FinCEN and say, give us all information that you have under the CTA about this person, then that's a fishing expedition. If they have to say, no, we want information about this LLC or this company, they have to identify the entity first, I think it's more robust. But we don't know how that's going to work in practice. And so I think, to me, this is like a gold mine of data for these foreign governments that are going to be engaged in fishing expeditions, and that really concerns me.
Thank you for your comments, and I've been following your writings over the years. Thanks for being here. Great stuff. Any other comments? And we have a couple minutes left.
I got a quick one.
Yeah. You want the mic?
Sure. Yeah, I was just thinking about some of the comments that I think Brett made yesterday about the special purpose entity thing, and I think we as an industry need to be careful here about who's responsible for what. I think we're the conversation that kind of concerns me is we've kind of glossed over who has the reporting requirement, and I've listened to some of the comments. It seems to have morphed into, oh, the trust company does. Right? The reporting requirement is at the entity level, right? Sure, the trust may need to be reported as an owner, but that conversation then bleeds into like, well, do we have to disclose the beneficiaries? And that is a nuanced, analysis that is legal work. Yeah. And I think we all just need to be aware of that. You got to be careful that we don't wave some flag that says, hey, we're now in charge of reporting, the underlying structures, their makeup, because it's not on the trust level. It's at the
Completely agree with you. I'm glad you hammered that point home. I mean, and that's where we struggled at Bridgeford, as I said, because, well, we don't want to assume the responsibility if we don't have it, because then that becomes liability. Then we have liability, right? So you're right on point. Back to some of the confusion on it. Anybody else? Any questions? Oh, yeah, please.
So I think the main point you made was we're going to try, this act is to try to reduce money laundering. So I guess do you expect in 12 to 24 months we will have no more money laundering? Or
yes.
What's the goal? I mean, is it a 50% reduction? How? What's the reality of this?
That's the million-dollar question, right, or whatever. I'm a little more pessimistic than my friend who spoke first. I don't see it as being particularly effective. That's just my opinion, not the opinion of Bridgeford or the South Dakota regulators, but mine. I don't know the answer. I don't think anybody does, which means we're going through a lot of trouble and a lot of hassle and spending enormous amounts of money, not even sure we're going to achieve our goal at all. That's my point. Yeah. Oh, Terry.
I think one of the big questions for a lot of trust companies in this room that have reporting companies in their trusts are what the gentleman over here talked about, is who not only is in control, but how are directed trusts handled? Because, face it, that's a lot of the trusts in South Dakota, probably over 50% or more, are directed trusts. And in directed trusts, the issue of who is in control is totally separate from who has the 25% or more ownership. That's pretty easy. The other issue that I think is really going to come up is the fact that you've got till January 1st to report, and then you've got 30 days after you, or maybe 45 after you start a new company, but is the changes in that information, because you've only got 30 days after there's a change in that information. So if a manager of an LLC changes his address, 30 days, and you've got to file a supplemental report. If the manager of an LLC changes from their maiden name to a married name, 30 days, and you've got to file that report. One of the things that FinCEN has done is they've allowed a FinCEN identifier, which you can get a one-time deal, and it isn't a big deal. I've done it myself, and it took 2 minutes, and then you just have to, then you can report that FinCEN identifier on all the documents, and you just have to keep your FinCEN identifier information updated, but you don't have to go back to each LLC in which that FinCEN identifier would be used. And so I think that those are a couple of things that people should be aware of here, especially with the directed trust situation.
Thank you, Terry. That's perfect.
I think, hey David, thanks for your comments. I think one thing that's important, as David said, you don't want to engage in the practice of law from within the trust. And there are, there's the high end of having a particular lawyer help somebody analyze the situation. There are other solutions like Dashboard. We've got a good solid software here out of Rapid City Secure Compliance that provides a dashboard that people would do it in-house if they had enough need for that, as far as your clients with maybe multiple obligations. And then there's, one of our other vendors here, Parasec, offers a solution. Mm-hmm. So there's a variety of solutions out there where you can adhere to David's advice. However, one thing that I think is critical for you from a customer service relationship, and that is to make sure your clients are aware. And so if you haven't sent some sort of notification or one-pager alerting your clients to the fact that CTA exists. As David alluded to, FinCEN did not do a great job notifying people within the country, and they estimate there's 32 million entities that are supposed to report within this first year, and many of those are just simple investment LLCs or holding companies that our clients might have. And so I would strongly encourage you within your organization to decide what that message to the client is, and if you have not gotten that message out to the client, to do so, you can tell them to speak to their lawyer, or you can, if you have relationships with particular providers, attorneys, or software solutions or others, you can also recommend those if you feel comfortable. But do have that so that there is not an assumption that because you handle other things, maybe other tax returns or corporate filings for that entity, that there's an assumption you're just going to do that. You might not be on the legal hot seat for that, but you're definitely going to be on the customer relationship hot seat if you don't have that communication.
300%, perfect. So I think we're at the end of our session. I'll just say this. Thank you again to the association for everything they're doing for our industry. Thanks for having me here. My message really is simple. Privacy and asset protection still exists even in a transparent world. It exists in South Dakota. And the work we're doing out of South Dakota, as I said a few times, is virtuous. I think we should be proud of it. And I think obviously the CTA is serious. We have to follow it, we have to comply with it, and we have to help our clients understand it. So enjoy the rest of the conference. Thanks again for the cold weather and snow. Can't wait to leave. Take care. No, just kidding.